So we might as well begin. Welcome everybody. Today's webinar is actually the first webinar I've ever given. It's obviously to do with cladding and whether we're at risk. And there was just a few housekeeping points that hopefully you've picked up on. If you lose us, click on the invitation link and it should bring you straight back in. If you have any questions, feel free to click on them in the question and answer function, and we'll try and deal with them at the end if we can. If we can't, we promise to follow up directly after the seminar by the end of the week. We haven't had any questions yet, so be brave and feel free to ask some. I've also set out a poll because we thought it would be, we were conscious that we had 200 acceptances, which is phenomenal for a webinar. I've seen a flurry of activity of people joining. We've currently got 113 logged on at the moment, and that's rising. So what I'm going to do is just publish now the results of the first poll. I'm going to end the polling now, and so everybody gets a flavour of who's in the room. You should see the results there. We're conscious that there are a number of competing interests in the room, and thankfully, because it's a virtual room, nobody will come to any blows. But you can see that the majority there, we have 40% are residential tenants or flat owners. We have a few landlords, building owners, a few developers, a couple of local authorities, some managing agents, quite a few surveyors, and 3 cladding companies. So that's just an idea of who's in the room, just so you know basically where we're aiming this. I will be launching another poll. In fact, let's get on with that now. The second poll, which will be in relation to cladding costs. And I'm going to launch the poll now, and feel free to vote. And in about 15 minutes, when I finish my bit of talking, I'll release to you the results of that question. Before we start, I just want to explain who we are. I'm David Marsden, a partner at Freeths in the Property Litigation Department. We have Simon Allison, a barrister at Landmark Chambers, and also Brooke, a barrister at Landmark Chambers. Simon and I have decided to go for the isolation haircuts. Not quite sure whether Brooke got the memo. I'm going to kick off with 15 minutes worth of just talking about what the government have been doing. But before we do that, I wanted to just reiterate to everybody that the reason we are here is because of the tragic loss of life at Grenfell Tower. And whilst we will talk in some detail about the legal issues and about the fire, the one thing we don't want to do is disrespect anybody by the loss of life. And so I wanted to start by mentioning that the reason we are here is because of that tragic loss of life. And whilst at the moment we have on the news daily death tolls, what we should never get used to is a loss of life. So let's start with the easy bit. What is cladding? Well, cladding is a non-structural external element to a building, and it generally has a couple of functions. The first function is usually to insulate, and the second function is to improve appearance of a building. Now, why can it be a fire risk? Well, it was BRE who did the report on Grenfell said that the external cladding has significantly contributed to the spread of fire at Grenfell Tower. And what happens is that the fire acts like a chimney for the flames. The gap between the cladding and the building wall acts almost like a flue to allow the fire to spread rapidly, particularly if it's not fire retardant. We will be talking in some detail about the cladding, and one phrase that you'll be hearing a lot of is ACM. Now, just in case nobody knows, ACM is aluminium composite material, and it's basically the type of cladding that was used on Grenfell Tower. Now, a lot of people think that this problem started with Grenfell Tower, but it didn't. You can see on the screen now a list of history of fires with a direct link to ACM. Obviously, the most important of those was the one in Shanghai in China in 2010. That's the list up till 2016. And then in 2017, we have Grenfell Tower. Now, Grenfell Tower was a 24-story building. It had 120 1- and 2-bed flats. It had non-structural partitions and 1 stairwell. It was constructed in 1974 and was refurbished in 2016 at a cost of 8.7 million. My understanding is that initially the cladding was supposed to be a fireproof cladding, but the budget had to be revised, and as a result, they decided to go with ACM instead. The upshot of that was that they saved £300,000, and with hindsight, that was obviously a poor decision, because at least 72 people died and at least 70 people were injured. Now, the government response to that was to do some testing on the ACM that was the cladding used on Grenfell. So 7 tests were undertaken so that urgent advice could be issued to building owners. And these were the tests. There are 7 tests, and they're essentially ACM cladding with different fillers. The upshot of the testing was that tests 1, 2, 3, and 7 all failed. Now, tests 1 and 2 are what are known as ACM Category 3 cladding. And the expert panel's advice on that type of cladding is that no system containing that cladding could have met building regulations. And so any building with that cladding has a significant fire hazard. If a building owner finds that they have a building with that type of cladding on it, then they ought to be considering at this point short-term interim measures, which the government have listed in order to try to lessen the fire risk while the works are being carried out. Now, tests 3 and 7, the expert panel said was unlikely to have passed building regs. And as a result, the government introduced a fund. Now, the first fund was for 600 million, and 400 million was for the social housing sector, and it was announced on the 16th of May 2018. A further 200 million for the private sector was announced on the 9th of May 2019. Now, this is only for replacement for the cladding that was used on Grenfell Tower with Class A1 or A2 cladding, which is cladding which is less flammable. The cladding itself is put into different categories, and A1 is non-combustible all the way through to F, which is easily flammable. This grant was only for buildings over 18 meters in height, and there was a deadline of December 2019 to apply. The difficulty was it required a declaration form from each leaseholder. And as you will be seeing with the new fund that's just been announced, it was conditional upon warranty claims being pursued. And so what the parties had to do was, if there were third parties they could pursue, they had to pursue them, and any monies recovered would be paid back into the fund. Now, we are hearing that some awards under that original fund have been starting to be paid in the last couple of weeks. And essentially the purpose of the fund was to replace the ACM cladding, the Category 3 cladding, with a more satisfactory cladding, less combustible. Now, further testing took place because the cladding the focus initially was on the ACM cladding, but it was initially the government said that because there are obviously different types of cladding, and the focus then turned to a cladding called HPL panels, which is high pressure laminate. Now, high pressure laminate is essentially sheets of wood and resin which are bonded under heat and under pressure to form the cladding. Now, initially the government said that provided that it was used in combination with a non-combustible insulation, then it was fine. But further tests have been carried out, and it's found that actually high pressure laminate cladding, if it incorporates fire retardant chemicals when it was produced, and if it did, it's often referred to as FR grade cladding, then that would usually fall within class B S1, which is fine. If, however, there were no fire retardant chemicals, then it would fall within class C or D, depending on its thickness, and would need replacing. So the government produced a report talking about that, and then very recently the government announced a new fund. That new fund was announced on the 11th of March 2020, and it's on top of the 600 million ACM fund that we just talked about. It's £1 billion, and it's for both private and social sectors. Now, the government said at the time that they released it that this £1 billion was, that's it, that's your lot. I would imagine that, bearing in mind what's happened recently with the coronavirus, that they really do mean that now. But applications are likely to open in May 2020, and with £1 billion, whilst it sounds like a lot of money, the estimate is that it's seriously underfunded, and it will only cover approximately 15% of the actual buildings that require it. So what we are seeing is that smart people are getting their applications ready now, so that as soon as the date for the applications opens, the applications are ready and can be sent in and can be drafted. So there is work to do, and work to do now. Each application is considered on a case-by-case basis, and it will cover Euro Class D and C, which is high pressure laminate, which we talked about, some types of timber cladding, and some types of external wall insulation with a render. Now, one example of that is EPS polystyrene, which is essentially the polystyrene that you would find for example, your laptop, when it comes in a box, it's packed in polystyrene. It's that type of polystyrene, but then a render is put over it, and that's perfectly okay whilst the render is intact. But if the render is compromised in any way, then the polystyrene itself it has flammability issues. What the fund doesn't cover is other safety defects like missing fire breaks, faulty compartmentalization, I got that right, that's the first time I managed to get that right, waking watches, and fire alarm installation. And again, with this, it's conditional upon building owners pursuing all other legal remedies available to them. So what we anticipate will happen is that when applications open, the applications that will go through the quickest will be the ones that are accompanied by a letter from a legal advisor, essentially saying that they've considered all of the other options, and either there are none or there are, and these are the steps that have been taken so far to try and pursue the remedies against them. You won't have to go all the way to do it, but you just have to at least show what's being done, because obviously anything that's recovered goes back into the fund. And as with the other one, there's an 18-meter height limit. Now, we thought that the driver for change would be, following Grenfell, would be the government. The government, to be fair, have made funds available, and they've explained what the required steps are before being eligible. But what we are actually finding is that it's the insurance market that's driving this change. Because what the insurance market are saying is that the premiums on any building which has non-compliant cladding are increased. And they are also saying that whilst the premiums are increased, and often we're finding that the premiums are doubling, and these are hefty premiums to start with, they're also saying that in the future, they may refuse to provide any cover for that building. Now, the effect of that is pretty obvious. Not only can you not have a building that is uninsured for fire, but if a mortgage company found out about that, for example, a residential flat was uninsured, then they would undoubtedly see that as an event of default and try and call in the loan. And you would think, as a result of all of this, that the measures taken on ACM clad buildings would have been pretty well progressed by now, but they're not. This is data from March 2020. There were 457 high-rise residential and public buildings. 144 have been dealt with, and 313 haven't, of which you can see on the list 182 are private residential. Now, that's just the data on ACM clad buildings. There is currently no official data on high-rise clad buildings with other forms of combustible cladding, so there will be thousands more. And you would have also thought that the local authorities will have been moving on this. There's a table there of local authorities with 1 to 5 buildings. I'm currently sat in Birmingham, and I see Birmingham's top of the list. But then, even worse, are some authorities with over 20 buildings still to be fixed. Now, what I'm going to do now is I'm going to hand over to Brooke, who's going to talk about enforcement. But before I do that, I just published the results of the poll. I'm going to end the polling now. The question was, who do you think ought to be responsible for the costs of replacing cladding? And 87% of you have voted, so thank you for joining in on that. I'm going to end the polling now and share the results with everybody. And the clear winner on that is the developer. 44% of people think that the developer should be responsible. 30% think it's the government. Then you have 11% think it's the landlords. 9% think it's the cladding company, and 5% think it's tenants. As stated, I will now hand over to Brooke, but before I do that, I'm going to just launch our third poll. The third poll is, who do you think ought to be responsible for the costs of other fire safety measures, not cladding? So I'm going to launch that poll now. Please feel free to vote on that. And I will now hand over to Brooke to deal with enforcement.
Hello, everybody. Let me just get my slides. Okay, so I'm hoping that that will now mean that you guys will have my slides up on the screen. So the first thing I'm going to talk about is enforcement. And in particular, I'm going to spend a bit of time going through two main statutory regimes that may be used to ensure that cladding, flammable cladding, is replaced in buildings. I have to apologise, this section is going to be quite law heavy. Unfortunately, that's kind of necessary because we are all lawyers, firstly, but secondly, I think you guys probably want to understand how this all works. And certainly in my experience over the last year or two, both landlords, managing agents and leaseholders have been keen to understand what responsibilities there are in respect of these buildings. So please accept my apologies for too much law for the next 20 minutes or so. So the two regimes I'm going to be talking about are the Regulatory Reform Fire Safety Order 2005 and the Housing Act 2004. Now, the Regulatory Reform Order is sometimes referred to as the FSO or the Fire Safety Order. They all mean the same thing, and we'll start with that one. What this is really is a piece of legislation, obviously, that's 15 years old, that sets out what fire safety obligations there are in relation to certain types of premises, and it sets out the enforcement mechanisms available in respect of those. The fire safety order applies in relation to all premises that are not expressly excluded, and we'll start then with what the definition of premises is under the FSO. Premises includes any workplace, any vehicle, any vessel, aircraft or hovercraft, any installation on land, and it also includes any tent or movable structure. So first thing to say from that is premises is very broadly defined. So sort of the starting point is if the premises is one of those things I've just talked about, it will be covered by the fire safety order. The main exception, however, and the main exception that's relevant for our purposes, is that the fire safety order doesn't apply in relation to domestic premises. Domestic premises are in fact outside the scope of the order. And domestic premises is further defined in the order, and I haven't included that on the slides because I don't want to bombard you with too much information. But in essence, a domestic premises is a private dwelling. So the important thing to note from that is that although a whole building, so a whole block of flats, is a premises to which the fire safety order applies, an individual flat itself actually falls outside the scope of the order. The next thing to say is that the fire safety order imposes a whole range of duties and obligations on different types of person. I don't intend really to go through every individual obligation, not only because that would bore everybody to death, but also because there's simply not time. What I have put up on the slides, though, is Article 8, which I think is probably the most important obligation for you guys to consider today. And Article 8 says that there is a duty on a responsible person to take such general fire precautions as may be reasonably required in the circumstances of the case to ensure that the premises are safe. The first thing to say about that is that that duty is, of course, quite broad and pretty unspecific. So reasonably required in the circumstances is the type of phrase us lawyers are used to, but in actual fact it appears quite waffly and can be quite difficult to pin down. The order doesn't say you have to replace combustible cladding. In fact, the order doesn't deal specifically with cladding at all. Rather, it's the implication from this kind of obligation that in reality, if you're dealing with a building where there is unsafe flammable cladding, it's likely that you're going to be reasonably required to ensure the premises are safe, and in doing so, replace the cladding. So the next question then, for our purposes, and I'm sure you guys are keen to know, is who has to comply with the fire safety order? Now, the first person who has to comply is who's referred to as the responsible person. And then I've also put on the slide a second category of person that has obligations under the fire safety order, and that is every person other than the responsible person who has, to any extent, control of those premises so far as the requirements relate to matters within his control. Now, it seems to me, and certainly from the instructions I've had over the last couple of years, that people often overestimate essentially the importance of working out who the responsible person is, when in reality there are lots of people who have obligations under the fire safety order, not just the landlord, but also managing agents, any employers within the building. There can be a whole host of people who have obligations under the order. And it's not as straightforward as simply finding out who the responsible person is. In actual fact, lots of people have obligations, and that can be quite frightening in some respects, because it can be people that didn't anticipate that it had anything to do with them at all. So that's a really important point to take away from today, that even people who wouldn't expect to be responsible actually do have obligations under the fire safety order. So in terms of enforcement for non-compliance, so assuming we've just talked about that there are broad obligations and responsibilities under the order, assuming there has been non-compliance, then the person who will enforce non-compliance is the Fire and Rescue Authority for a particular area. And there are powers to inspect, and those inspections can be quite rigorous in that they can require documents to be produced. Obviously, the fire safety risk assessments are going to be really, really important. So there is always a risk, essentially, of an inspector coming around and checking whether or not you're in compliance with the order or not. The Fire and Rescue Authority have the power to issue notices. That can be an alteration notice, an enforcement notice, or indeed a prohibition notice. And they are relatively self-explanatory what they are, and they can be really serious if one is served in respect of a building. The next thing to say is any non-compliance with the notice constitutes an offence. So if you receive a notice, it's a really serious matter. You need to take advice pretty quickly, and you need to do something about the situation pretty quickly, because if you don't, there'll be time limits within that notice, then you will be committing an offence. Secondly, and this is perhaps less well known, the failure to comply with any of the fire safety duties may amount to an offence in circumstances where that failure places one or more relevant persons at risk of death or serious injury in case of fire. So it doesn't mean, you don't necessarily have to be given a notice in order to potentially be committing an offence. So obviously this is really, this is really serious stuff, and this is a demonstration of precisely why you need to have up-to-date fire safety assessments and risk assessments that have been carried out, and that you need to think about what your obligations are and be proactive about this, not wait to hear from the enforcing authority. But before I move over to the Housing Act 2004, what I wanted to finally mention is the Fire Safety Bill that was introduced in Parliament earlier this year. Essentially, the government has proposed to make some changes to the Fire Safety Order. It received its first reading in Parliament on the 19th of March, so only just over a month ago, but obviously the world has changed somewhat in the last month. Perhaps most importantly, the bill would clarify the situation in relation to this type of issue. So if the bill were passed, essentially what it would require is that the building owner has to both manage and reduce the risk of fire related to the structure, external walls of the building, and specifically including cladding, balconies, windows and entrance doors to flats. So if the bill were to be passed at some point in the future, it would make the fire safety order much more specific to the issue of defective cladding. Obviously, given the present situation, it's very difficult for us to know if or indeed when there'll be a second reading of that bill. Okay, moving then on to the Housing Act 2004. This is a broad piece of legislation, and those amongst you who are private landlords perhaps, or from local authorities, will probably be familiar with it, because it's a big piece of legislation that deals with much more than simply the issue we're going to be talking about today. In general terms, the 2004 Act has aspects of it that are intended to improve housing standards and to impose duties on local authorities to improve standards in their area and to require that remedial works be carried out. The 2004 Act established essentially a whole new method of assessing housing conditions and evaluating hazards for enforcement purposes. So there are category 1 or category 2 hazards, and fire safety problems and defective cladding could be a defect or a hazard within those categories. Local housing authorities are entitled to carry out inspections, just as I've said earlier, the Fire Safety Authority can. Local housing authorities can also carry out inspections. The next thing to say is, how does the 2004 Act apply? Now, unlike the fire safety order, the focus of the Housing Act 2004 is actually in relation to residential premises. So usually, if there is enforcement under the 2004 Act, it's in relation to a flat owner or an owner of a house. And it tends to be that local authorities are trying to enforce housing conditions in relation to specific owners. There is an exception to that because the Act expressly provides that in the case of premises containing flats, action may be taken against the owner of premises in relation to the common parts of a building containing the flats if the authority is satisfied that the deficiency comes from those common parts. So if the issue is the cladding, it seems to be the case that that will be treated as a common part, and therefore the local authority can take enforcement action against the owner of the whole premises, i.e. the whole building, rather than individual flat owners. It's important to note that the local housing authority has to consult essentially with the fire authority before bringing any enforcement action, and that's obviously to prevent there being an overlap of powers being exercised. It depends on where you live and what the local cooperation is like to know whether or not local housing authorities and fire authorities are actually talking to each other. But that requirement for consultation is in some respects good, because it does mean at least you shouldn't be on the end of two notices, one from different people. There should hopefully be some kind of cooperative approach taken between the different authorities that have different powers. The next thing to say before I move on is who is an owner? And I don't want to spend too much time on this because it can be a quite complicated question, but who is to be treated as an owner of premises when we're dealing with an issue such as the cladding? Now, the 2004 Act defines owner as being a person who is, for the time being, entitled to dispose of the fee simple of the premises, whether in possession or in reversion. Now, in English, that means the freeholder. It also includes a person holding or entitled to rents and profits for the premises under a lease of which the unexpired term exceeds 3 years. And in English, that means intermediate lessees. So what's important to note here is the owner for the purposes of the 2004 Act can be either a freeholder or an intermediate landlord. There is a case that says a right to manage company is not an owner for the purposes of the 2004 Act and these enforcement proceedings under the 2004 Act. And the case, if you want it, is a case called Hastings Borough Council and Breer Developments, and it's a case in the Upper Tribunal from 2015. So similar to the powers we've already talked about under the 2005 Fire Safety Order, there are 3 types of notices that can be given. A hazard awareness notice, which is what it sounds like. It's a notice to tell a property owner that there's a problem and to recommend usually that something be done, though it's not a requirement to do something, but it's a notification essentially. Then there's the improvement notices that can be issued under Section 11, and then a prohibition order. Now, it seems to be the case that probably the most likely notice that might be served is the improvement notice. And the reason I say that is because a prohibition order would essentially close down a property completely so no one could live there. And if a local authority issued one of those, they would be on the end of however many people had been made homeless. They would have to then worry about the homeless applications and essentially accommodating those people who'd suddenly been made homeless. So I suspect improvement notices are the most likely one that would come up essentially. And we've already talked about who the owner is, and essentially one of these notices will be served on the owner, someone who's an owner within the 2004 Act, and the person who the local authority considers ought to take the action that is required. Now, it's important to note there that's discretionary. So if you're dealing with quite a complicated lease structure where you've got a freeholder, several intermediate landlords, and then occupational leases, there may be a number of people, and indeed perhaps a management company, there may be a number of people who it looks like ought to be taking the relevant action, and the local authority will have to look at that and decide who they think is the most appropriate person. That leaves an element of discretion, and it also leaves an element of, you might be served with one of these notices and find it very, very difficult to comply. If that's the case, you can appeal one of these notices to the first tier tribunal. Failure to comply with one of these notices, either the improvement notice or the prohibition order, is an offence, and we've already talked about the potential offences under the fire safety order already. So there's two sets of statutory regimes that can result in prosecution if you don't comply. The final thing I wanted to say before I hand over to Simon is that despite the Grenfell fire tragedy, and despite sort of the heightened importance, essentially, or the perceived heightened importance of enforcing issues with cladding and carrying out remedial works, there has been a notable lack of enforcement, both by local authorities and by the fire safety authorities. Now, whilst I think that there has been a degree of patience, I think that is probably unlikely to continue. And the reason I say that is there has been a couple of years now for people to sort this out. There is now money available, especially in relation to cladding. And I suspect in the next few months, the patience of fire safety authorities and local authorities it will start to wear thin, essentially. And I think probably in the next few months, and certainly in the next 3 to 9 months, we can expect much more enforcement action in relation to flammable cladding and the replacement of that cladding and the need to do so. On that note, I think I will be passing over to Simon. So if you give me a second, I will.
While Brooke is handing over to Simon, I just share the results of that poll. For the responsibility for the costs of other safety measures, not cladding, developer wins again, but landlord looks like much higher. I'll leave those results up for a second, and then while Simon's coming on, we'll put out the last poll. Simon will then talk. I will finalise, and then we'll try and deal with some questions.
Great, thank you. Hopefully everyone can hear me. I'm not sure why I'm appearing in my garden, but there we go. So that's the background and the enforcement framework that everyone is working to. And I'm now going to look at some practical issues, and I've seen many of your questions, and lots of those are related to the practical issues, including who's going to pay. And a little look at the what's coming up in the future. Now, the next slide is a somewhat depressing picture, I'm afraid. I've now seen, I think, nearly 40 blocks that I've advised on since the Grenfell fire, and I have started to see a pattern develop in those cases. So in the vast majority of the cases, what happens is you discover one substantial fire safety concern in a building, and then you find more. So a common pattern that you'll find is the building owner or the manager gets the cladding tested, we discover the cladding is combustible, and then of course you instruct an expert or a cladding engineer, for example, and they will take off a panel, have a look behind so as to investigate and see what remedial work is required. They then discover behind there there's a lack of fire breaks. They see some insulation, it's not marked, then they get the insulation tested, that's found to be combustible, and then you find the cladding's not properly fixed to the rails, or even the rails aren't properly fixed to the building. These are all common defects I have seen. And then we find that some of the services are penetrating the cladding, then we're getting into compartmentation issues, and so on and so forth. And next thing you know, you're looking at the inside of the building, there's compartmentation issues in the building, including in some of the flats, and so on and so forth. I've even had one case where it got to the point where we were looking at the steel structure of the building, and the steels hadn't been treated, they had no proper fire stopping on them. And where do you stop? So that's not going to be the situation in every case. I often am only looking at the worst cases, but the lessons are, firstly, if you are, or your landlord is setting a budget for proposed remedial works, be careful, because I've often seen situations where costs escalate quickly. So when you're setting budgets, get all the facts first. The second point is that it's pretty vital, I think, that the communication with the leaseholders are regular and are honest, because some of the best handled situations that I have seen have been where leaseholders have been kept up to date with realistic answers to when is this all going to be sorted and how is it going to be, how much it's going to cost, and staying honest, because retaining the trust of leaseholders is one of the key ways of getting through these issues, because otherwise you can get bogged down in arguments about what's going on rather than getting on with actually doing the work. So I'd encourage any managing agent or landlord that's thinking about how to deal with these situations to bear that in mind, because retaining trust between the people living in the property and the people dealing with the management issues is absolutely essential. So we come on to who might pay. Of course, this is one of the most controversial things to have developed over the last 3 years. I saw in the poll 75% of you thought a developer or the government should be the party sorting things out. I wouldn't disagree with that assessment. And central to the arguments here is the underlying point that in most cases, neither the leaseholders nor the current landlord had anything to do with the issues that have arisen, because they had nothing to do with the development of the block. And of course, the other issue is that in most instances, leaseholders' first reaction can be to think that the landlord should pay, or at least should sort it out, and shouldn't recover the cost from leaseholders. And that's been encouraged by the government, who've been saying simply, they've just been repeating that landlords should do the right thing, whatever do the right thing means. It certainly doesn't mean a legal responsibility. And I think it's worth seeing these arguments from both sides, because from a landlord's perspective, why is it the right thing that the landlord pays? It's important to understand the economics of the situation. The value of a freehold of a block of flats might only be 100,000, 200,000, and it might have 80 flats each worth £250,000. So the landlord's financial interest in the property is pretty small, a few £100,000, and the cost of the remedial works to fix the cladding will be running in most instances into the millions. And when you bear in mind that many freeholders are institutional freeholders, so they are investing money on behalf of pension funds and individual investors such as you and I, it's very difficult for them to justify paying for the cost of works when there are provisions in the lease, for example, to recover money from others, and also, of course, potential claims against third parties. So that's the context. It's hard to see why either the freeholder, as long as they weren't the developer, or the leaseholders should be paying. So who else might be on the hook? We've got a few people on the screen. Lots of instances of developers paying up, as it happens, rarely because they are legally responsible, but on occasion that's happened. More often because of the reputational risk, which is very high, particularly for household household name developers. So don't underestimate the power of just simply putting pressure on the developer, irrespective of whether there's any legal merit, frankly. And I've seen some very effective campaigns against developers to get them to pay up by leaseholder groups at particular developments and indeed on a more national basis, and getting involvement, political involvement from local MPs can also work well. So that's certainly an avenue to explore. It's relatively unusual for the developer to be legally liable simply because of the passage of time, but we'd have to look at it in every case. What about building inspectors? Well, they've got a lot to answer for, haven't they? Because someone signed off almost all these buildings. I do have one case where, in fact, nobody had ever signed it off, but that's pretty unusual. I'm afraid the short answer about a claim against a building inspector, whether it's local authority building control or private building control, is it's extremely hard to do. Unless you can prove some kind of fraud, it's going to be exceptionally difficult. So much as I have a lot of sympathy for that claim, potential claim, it's very unlikely to succeed. Warranty providers. So here we're talking about people like NHBC and Zurich. Often you get a typically 10-year warranty when you buy your flat. It's absolutely vital that you check, as soon as you're aware of any issues in a block, whether there is a warranty in place, and if so, what the terms are, and make sure you notify the insurer. Because I've seen several cases now where policies have expired after the date of the Grenfell fire. So, I mean, in one case, I think it was November or December after the Grenfell fire, and the managing agent had been well aware of cladding issues at the block since September, hadn't thought to notify NHBC, nor had any of the leaseholders, and the claim was lost. You can't bring a claim outside the 10-year period. So always check. So as time goes on, there's fewer and fewer claims that will remain as against the warranty companies, but it's an obvious potential source of funding. So if you haven't checked already and you're dealing with cases where there are fire safety issues, check now. The government, David's already covered that, so I'm not going to go over that again. It's worth noting that the government funding will not be available where the landlord wouldn't be able to pass on the cost through the service charge. It's there to protect leaseholders, not to bail out landlords, so that's one thing to bear in mind. And personally, I highly doubt the 1.6 billion of funding is going to be anywhere near enough, but we shall see. So what about the landlord? Well, if the costs are not going to be covered by any of those third parties and the landlord can't recover it from the leaseholders, ultimately, in most instances, the landlord is the party that is under a statutory obligation, for the reasons that Brooke set out, to resolve the issues. Either the landlord or the named management company or RMC or potentially an RTM company, but the party with the management responsibility. So ultimately, the landlord has to pay, or the RTM company has to pay. And the second question is, can those costs be passed on to leaseholders? But the principal obligation will start with the person with the management responsibility, and Brooke's taking you through who's a responsible person, so on and so forth. But what the landlord will in most instances do, if they can't recover from the warranty provider, the building inspector or any of those, they're going to be looking to leaseholders to pay. How do they do that? Well, via the service charge provisions in the lease. And we'll come on to that in just a second. But just as leaseholders are typically paying for the costs of cleaning the block, for insuring the block, so the costs of keeping it in repair are part of it. And the question is whether, for example, replacement of cladding is one of those costs. I put managed agents at the bottom of the list simply because there will be some instances where managed agents don't deal with these cases very well and potentially will be on the hook for a professional negligence claim. Why? Well, because they're often insured, so they're an easy target when you get lawyers involved. So that's the potential list of people you'll be looking at. If you come to see one of us with questions about who's going to pay and what's going on, well, what does the lease say is probably going to be our first question. It's where all lawyers start in these sorts of cases. And it's vital to consider the particular form of each lease. They vary hugely from development to development. They vary hugely over time as well. Modern leases tend to be written in a much fuller style. The real importance of looking at the lease in the context of this talk, there's three reasons. The first is it's going to tell us who is liable for which parts of the block. So you'll recall when Brooke was talking about the fire safety order, we were focused on who has control over the fire safety in issue. Now, generally the split will be obvious, but I mean, there's an example on the slide here where a draftsman of a lease has tried to define what the common parts are by listing every conceivable part. And you can imagine I was dealing with a case where it didn't actually address the part that we were thinking about, and you're left with a mess. So you can end up with grey areas, either because the lease isn't dealing with it or at the intersection between, for example, the flat and the common parts. The second reason we're going to be looking at the lease in these cases is we want to know what rights the landlord or the manager has to go into the flats to do works. So a common example is if you're dealing with compartmentation issues. For example, you might need to seal around a common service duct that passes through from the common parts into the flat. It might be a heating pipe or cables, whatever. And it might only be accessible from the inside of the flat. So whoever's managing and doing the block, doing the works is going to want to know on a practical level how they can do some fire stopping and whether they can ensure leaseholders give them access. But another common example is that often you'll find the fire service will recommend the installation of a full building fire alarm system. That's because most blocks are built on the assumption that everyone will stay in their flats if there's a fire, a stay put policy. Most of you will have heard of that. And where there are serious issues in flats, you'll often move to a full evacuation, in which case you'll need a much more extensive fire alarm system. The question is, can you actually install fire alarm sounders inside these flats and the detectors as well? And it's actually going to be very rare for there to be a right to install the fire alarm sensors and detectors inside people's flats, and you might have to deal with it by cooperation. You've got to check all that before you start doing these works, because otherwise you might find you embark on a project that you can't carry out. The third thing, of course, is the lease going to tell you what costs can be recovered through the service charge. And if it can be recovered through the service charge, is it all of the costs or not? So let's come on and look at that. So what you'll have in your lease is typically a list of service charge expenditure. Usually it's in one of the schedules at the back of the lease, and we'll be looking at that to see whether the specific works being carried out at a particular development fall within the particular wording in the lease. And much as I'm sure many of you would love there to be a standard list of service charge expenditure in one answer, every single lease is different. Great business for lawyers, I accept, but that's just where we are. You need specific advice on your particular situation. So I've listed up on the screen there some typical service charge expenditure. So one might be the costs of keeping the building in repair or good order or substantial condition. We'll return to that in a second. Or it might be to renew or replace or rebuild where necessary the building. Well, usually that's going to cover most cladding and fire safety issues if you've got a lease that refers to that. There's then the covenant to keep the building insured. Now there's lots of issues. I've seen lots of questions about building insurance coming up. This isn't referring to the actual availability of building insurance. This is the example where, as often happens, insurers will say, I'm happy to keep the building insured, but only so long as you comply with the requirements of the local fire service and the local authority. So the argument goes, well, therefore, the costs of replacing the cladding and putting in place a waking watch and installing a fire alarm, whatever it is a cost of keeping the building insured. which might sound like a bit of a lawyer's argument, and it is. And I've argued it in a couple of cases. One was the Fresh Apartments case. There's, I think in Nova House that was argued as well. It's another one to bear in mind, because landlords will be looking for any way they can in most instances to pass on the costs. Then we have some more obvious ones. So to comply with the requirements of the competent authority, that will usually cover these costs, comply with statutes and regulations, so that includes complying with the fire safety order. And then a sweeper clause, that's included at the bottom. That's the clause that says any other costs the landlord incurs, for example, in the interests of good estate management, things like this. Now, generally, the courts aren't keen on parties, on landlords, managers, using a sweeper clause to cover this sort of cost. But in the context of fire safety, they tend to be much more keen, because it's unforeseen. Costs often, this sort of thing wasn't seen to be coming, and also it's safety critical. So, so there's your list of service charge expenditure. There'll be real issues in older cases, in particular, with whether a simple repairing covenant that doesn't refer to anything else is going to cover the situation. It can be it can be an interesting, from a lawyer's point of view, argument as to whether cladding that is just sat there and hasn't deteriorated in any way really is out of repair, to which the answer generally will be, it's not. If the cladding is in just as good condition as it was when it was installed, there's no disrepair. So that's an area that's ripe for argument over the next few years. The last thing I'm going to touch on very briefly is what does the future hold? There's huge further changes on the way, but of course works to remediate buildings can't wait until all of those are concluded. So that creates a real difficulty for building owners, knowing exactly what it is that they need to do to remediate a building in a future-proof way. Nobody wants to spend millions on a building and you should be told, well, it doesn't comply with these standards, so you need to do it again. So we've had changes to the building regulations. This is approved document B, and there were amends last year, and there's more amends recently announced. So you're now, for example, in new builds going to see in residential towers where there's a story that's 11 metres or higher, developers will now have to include sprinklers in all of those buildings. There's a current fire safety bill which will make some amends to the fire safety order that Brooke was talking about. So that will confirm the liability of the responsible person for front entrance doors to flats, and it's going to confirm that the fire and rescue service have enforcement powers with respect to the outside as well as the inside of the blocks, and various other bits. We've then got a new building safety regulator being introduced. That's from the Hackett report. That's the one on the right-hand side. So that's going to be a building safety regulator that oversees safety in high-rise buildings. And high-rise in that context is going to be defined as 6 stories or higher. And that's going to develop over time. It's going to put quite a lot of responsibility on building managers, and particularly if you're in blocks where there's an RMC, i.e. a residence management company, where the leaseholders also own the freehold or own the management company, or RTM companies. That's going to be quite an onerous job for people in those sorts of blocks. Then finally, we've got this suggestion that there'll be something done about the deadlock with lenders, because at the moment I know it's very difficult to for existing leaseholders to remortgage or sell unless there's been some clarity as to the construction of their block. And there has been some work on that in terms of this scheme. I think it started by Barclays for blocks to be certified, but I know it can be very difficult to get that certification done, whether down to difficulties with the block itself or difficulties with dealing with the landlord or the manager. So I think that's all I wanted to cover at this point. I think we're going to come on to some questions now.
Thank you guys. What I was going to do was just basically try and sum up before we move on to the questions. I've shared the poll results for the last poll. they should be on everybody's screen so you can see what position everybody else is in. Simon, if you could just stop sharing your screen, that would be useful. I can then just my last few slides. And so what I would like to summarize with is why should people firstly, why should anyone really care? The answer to that is the first point of that is one of obvious safety issues. Everybody needs to be bothered about this because of safety issues, but tenants are finding that they are being faced with tens of thousands of pounds of additional service charge, a huge increase in insurance, the flats becoming potentially unsellable, and a risk of the mortgage loan being called in. And any delay, as Simon talked about, can see causes of action against third parties being lost. In relation to building owners, Brooke talked about the government and local authority and responsibility and the terms of the lease, and developers and cladding companies need to be aware that these potential costs are on the horizon and are coming your way. There are limitation issues that need to be grappled with and people need to understand, but be aware of what's coming because building owners are likely to be in contact. The way I see a typical example is that the tenants will now approach their managing agents and say, look, what's our position on cladding? Where are we? They will get what the position is. They will get legal advice on whose responsibility it is. The most likely scenario is that the landlord will be responsible, funded via the service charge. An expert you can get an expert on board and then work out your options about whether to apply for the cladding fund and who else, get some legal advice on who else to sue, because you're going to need that anyway for the application. And we have had a question, a live question about funding. And one of the questions was about group actions. And yes, we are already working with a number of parties, and you are right in your questions that these can be funded by way of group actions, and it's the economies of scale, isn't it? It's the more people you have with similar arguments against similar types of developers, you will share the cost equally. Similarly, there is available what is known as after the event insurance, which is basically insurance that says that will cover you for legal costs in the event that you are not successful. But of course, these are all things that we can discuss and explain if you need to. That really is it. What can tenants do? Basically engage with people. Initially, your initial advice you may well be able to get that paid for out of your sinking fund. It's there for a reason. And in light of the potential huge costs that might be coming your way, it's probably worth spending a bit of the sinking fund just working out exactly what your position is for the whole building. Hopefully that's covered everything. What we will now do is move to some questions. And as I've said, if we don't get to your question, we've got all of your email addresses. If we don't answer it properly, we will try and follow it up in the next few days. If we don't, if you feel that we haven't answered and you've got a burning question that you really want to ask us anyway, feel free to email me. The email address is on the screen. I can't promise to respond tonight, but we will over the next few days. I have also released, I believe, the results of the poll, so everyone can see it. So one of the questions that we did have was, and I'll read this out, is what support is available for people whose building has other fire safety issues that don't include cladding? My building was built without fire stopping measures between apartments. It has a lack of compartmentation and does not have the correct fire alarm system. Homeowners in this building are potentially being expected to pay up to £20,000 for the remedial work for safety measures that should have been done at the initial building stage.
I think that's me. You'll have heard probably from what has been said by all of us that clearly the focus has been on cladding, and the funding that is available is about cladding. And Simon's already talked about the difficulties with that, because there are going to be other things that are likely to require other works to be carried out beyond the cladding that you may not be entitled to money for. Ultimately, at the moment, there isn't any financial support beyond that, and the other fire stopping measures there isn't a separate pot for those, unfortunately, and the other people who will pay is essentially what Simon's talked about, those various people, depending on the terms of your lease.
Thanks, Brooke. Another question that we've had in was, who is liable for the costs of remedying cladding where the block complied with standards when it was built, but does not comply with current standards? In particular, what is the position where an RTM company has taken over management of the block from the freeholder?
I think I was going to deal with that. Of course, the question of who's liable for remedying the cladding is going to be really development specific. You need to take advice by reference to terms of the lease, and I sort of already ran through that. You need to look at the particular defects that have been found as well. In most instances, the cladding probably didn't comply with the standards at the time when it was built, never mind now. But there's a real issue with RTM companies. For those who aren't aware of the RTM scheme, it's the right to manage under the Common Hold and Leasehold Reform Act 2002. So it's a no-fault scheme where leaseholders can serve notice on a landlord if they have sufficient support, and they will, via their right to manage company, take over all of the what's called management functions under the lease. The question was, what's the position where an RTM company is taking over management of the block from the freeholder? Well, the answer is that if the freeholder was liable to repair the cladding prior to the right to manage being acquired, then now the RTM company is responsible for putting that right. So, not really the answer that RTM companies want, I know, but there it is. The key point is there's no special rules for RTM companies. You either comply or you risk sanction, and the sanction is against not only the RTM company but also the directors. So make sure that you have directors and officers insurance in place, and make sure you get on and do it. It's a real issue with RTM companies. David, I think we had another question on RTM as well, didn't we?
That's right. You've caught me on the hop on that one. The other question was, what happens if an RTM is unable to raise the funds and insurance is withdrawn from the development?
Yeah, so just carrying on the RTM theme, and it's not just an issue with RTM companies, actually. It's also sort of any resident-owned management company, for example, where leaseholders all collectively own the freehold in an RMC. And of course, the sort of great joys of being your own boss and managing the block suddenly come back to bite you, sadly. The short answer is that the RTM company's got to raise the funds if it's the party liable to do the works, which means agreeing amongst yourselves on the board that that's what you need to do, and then raising the funds from leaseholders. So you've got to send demands to leaseholders in accordance with the lease. You might have to go to consultation. But most importantly, you've got to enforce payment, because otherwise, unless you've got a really big reserve fund, you probably don't have the funds to deal with the cladding. If you don't do the work, directors are potentially facing prosecution under the fire safety order, as well as the company facing prosecution. So there's lots of strategies. I know this all sounds, a bit theoretical, because the practical realities can be rather different when you need to get the money out of people. So there are other strategies that you can look at as an RTM company or an RMC. You can look to appoint a court manager, for example. You have to make a specific application for that as a leaseholder. You can look at ending the right to manage so that responsibility passes back to the party that had it before you acquired. You can see if the freeholder will help. Depends on what terms you parted, I suspect. But I'd strongly suggest you take advice. If that's the situation you're in, we'd need to look at the particular lease, the particular circumstances. But given the risk of personal liability, please take advice, because it's a real issue for RTM companies. Now, the question was, if the insurance is withdrawn, that can be a pretty serious problem that you've got to deal with. If you're under an obligation to insure, you've got to insure. Generally, insurance costs are going to increase rather than insurance being completely impossible to obtain. So check other providers.
Thank you, Simon. We had another question. Most of the information about cladding seems to relate to high-rise residential blocks for obvious reasons. We know people who own a modern 4 or 5-storey budget hotel that has some ACM cladding. Is there a requirement to change this cladding, given that only 3 or 4 years ago, when the building was constructed, it complied, and the building is low-rise with modern fire doors and means of escape, etc.?
I think that's me. So whoever asked this question is obviously knows what's been said, and most of the focus in the last couple of years has, of course, been on high-rise blocks, and the funding has been targeted at high-rise blocks and allowing them to reclad those buildings. What about smaller blocks? Just because the block is smaller doesn't mean the ACM cladding is any less flammable. And the remedies I've talked about today don't expressly require the replacement of cladding. They impose obligations which may then require the replacement of cladding. Inevitably, the fire risk assessment for a smaller building or a lower building will be different to the risk assessment for a much higher building. The considerations will be different, escape times will be lower for a lower building. So the starting point for anyone in that situation, in a lower building with ACM cladding, is to go back to your fire risk assessment, make sure it's up to date, consider what the options are, take advice, and consider whether or not you're complying with the obligations we've talked about. It's also perhaps worth saying that commercial buildings such as hotels are built to different standards, and one of those differences is that a hotel will usually have a different type of fire alarm system, one designed for simultaneous evacuation rather than a stay put policy, which is the policy that we all know was in place in Grenfell. So there are lots of different things to consider on this scenario, and it's quite difficult to go into them in detail here, but ultimately whoever asked that question, you need to go back, look at your risk assessment, think through the obligations and decide what to do next, and probably you're going to need to take some advice, I suspect.
Can you hear me now?
Yep.
Yeah, that's better. Somehow I couldn't get to the mute button. I'm sorry about that. Well, we've overrun slightly. Sorry about that. What we have, we've tried to answer as many questions as we could live. We've also answered some of the questions that we received beforehand as well. What we will do is we will go through, we will save the questions, and we will go through, and if we haven't answered your question, then we will try and contact you. We have your email address. We'll try and contact you in the next few days to see whether we can give you an answer to your question. If you were too scared to ask a question, feel free to send us any queries to my email address. Hopefully you found it interesting. Any feedback, feel free to send it as well. We hope you enjoyed it. We've had a few questions about the slides. If you would like a copy of the slides, again, please email me. Other than that, thank you for joining us, and stay safe, everybody.